Thanks again. Welcome to another video with the 0%. Please be sure if you're looking to obtain the 0% tax bracket, go over to patreon.com/the 0% and begin the courses. I had a consultation today with a potential client of a very busy lifestyle, full of work, full of good work, serving the community. And signing up with us is it's exactly what they want to do. However, they just won't have the time to continue everything that's a part of the freshman, sophomore, junior, and senior classes. Therefore, the opportunity for that person is to let us do it. It takes anywhere from 3 to 6 months, which is standard, no problem. This person is in Texas, and I kind of wanted to share with you guys the importance of remaining anonymous when it comes to your business. Even if you are an employee, you want to remain anonymous and not have your name on anything. The whole point of a trust is that the trust can own everything and you control it. Own nothing, but you control it. And so had this person had everything set up as far as his business structure with a trust, he would have avoided what happened to him. Now, what happened was, long story short, out of all the businesses that they have established out of Texas and Oklahoma and other states, they've obtained what's called a group exemption under 501c3, which and another company under 508c1a, which is all the same thing. I don't care if they call it a church, or an auxiliary, or a charitable or religious tax exemption organization. It's all under the same code, which the IRS has control over. The one thing that they don't have control over is a foreign express trust, because it is foreign to Washington, D.C., and that is the main point. It needs to be foreign to D.C. because all states under the Act of Cession is now under the laws of Washington, D.C., so it applies to all of the 50 states, aka the 50 countries within the North American continent. But if your trust is established outside of that in another country with a legitimate non-resident alien, which is a foreign trustee who has no driver's license, no social, no green card, none of that, then you are completely out of the U.S. jurisdiction. You don't pass the U.S. court test and you don't pass the U.S. control test. Now, we've all heard this before if you are subscribers to the channel. If not, you're new, welcome, and go through all of the videos to understand what this is all about. We are looking to obtain the highest form of asset protection, and we are looking to remain off the radar when it comes to the IRS audit system. Now, even though this person had a group tax exemption, there was a random audit, and now they found that they haven't filed within the last 3 years. And so they're looking to find a way into their personal business and tax them. And they're especially going to do this to organizations that are under 501c3, the religious tax exemption, and 508c1a. They're looking and waiting for you to mess up. For example, if you read that 501c3, for a lot of pastors, there are certain things that they can and can't do if they want to have tax exemptions. For example, they cannot go against any political office statement when shootings are happening in the neighborhood, or when a political candidate says something that goes completely against the word of God. They can't say anything about it lest they receive some type of fine or imposition. And even if they don't go along with it, what can happen is all of the years that they have received tax exemption will now be due. And if they can't pay it, they can serve some time in jail. That is the catch-22. And this is a major issue within a lot of 501c3 corporations that are considered churches. So what I want to get into today is to show, why this is important. And even real estate investors, they do understand that ownership is not something that you want your name on. I can speak for personal experience in partnering with a real estate agent in commercial properties. I'm completely clean, but another venture that I wanted to get into, the other person was not, and I found out the hard way. You know, if that person is going to go ahead and put up the money to purchase the property, and I'm going to put up the money to do the renovations, what came back? We put the property in our names. And so there was something going on with him. And once the attorneys found out, and they did a natural search and found out that he had all of these properties, commercial properties in his name, well, guess who has to go down that black tunnel with him? Me. And this has happened to other investors who didn't know this information as well. So it's not worth having things in your name where you're easily a target and easy to find. For this potential client that I'm talking about, it was very shocking for them to receive a document in the mail from the IRS. It was a summons for them to come into court and to give a report as to why they didn't file for the last couple of years, to challenge their group tax exemption. It was a shock to know that his name was on it, his wife's name, including their children, was on it. And that's what you call being sued under personal capacity. That's Rule 17, the Federal Rules of Civil Procedures Act, Rule 17. It's exactly what happened. But to his surprise, upon our consultation, I told him, look, they really don't have anything to stand on. Your attorney that you hired told you the correct thing and not showing up in that summons, because the court is simply looking for a reason for you to tell on yourself, so to speak, for you to provide all of the information that they can use against you. And that's true. They love to do that. They'll do that all day inside of these administrative procedure courts, aka the abuse and neglect courts. That's one of their tactics. However, the summons was missing something that was very key to give life to the summons. A summons is synonymous with the word warrant. And if the warrant or summons is lacking an affidavit of complaint, which is approved by the judge, magistrate, or a clerk of court, then the warrant or summons has no standing. So this is something that was received to his office a couple of years ago, and it's still open. They haven't heard anything from the opposition, but I would have shut this entire thing down simply by challenging, doing an unconstitutional challenge, a 5.1 constitutional challenge. There must be an affidavit of complaint. Someone needs to be under penalty of perjury saying that whatever is the problem that they think you have caused or have not done, they need to state it, and it needs to be clear, it needs to be precise, it needs to be notarized, and it needs to be under penalty of perjury under the state that they're in or the United States of America. That's 26 USC 1746, Section 1, or Section 2 if done within the United States, aka the District of Columbia. That has to happen, and there needs to be a proof of service of that affidavit of complaint before a warrant or summons can come into play. That's Rule 8, standard. You must do that, and that's also inside of the Constitution. So I was very shocked to hear that the attorney didn't do that procedure. Most attorneys out there, they know court procedure, but they really don't know lawful information as far as the constitutions before 1933. So that was a part of his Bill of Rights in Texas, and also the Declaration of Rights in Oklahoma, and every state that he has property. So today we're going to go over the importance of structuring your business. Okay, I have always told you guys that from the very beginning, if you think of a pyramid, at the top of the pyramid is your foreign express trust. It's established in another country. I'm going to go ahead and share my screen here and show you a little diagram that I made, which should kind of make sense of this. Okay, let's try this again. Share my screen. All right. So this pyramid here, at the top, you see the Foreign Express Trust. Now I've titled this the Trust Enterprise, and you'll see why. Your Foreign Express Trust is a foreign entity to Washington, D.C. Below that, as we structure your process, or if you do it within the courses, you'll understand from the videos that this is the order that you must go in. After you've obtained your Foreign Express Trust, your specific EIN number by calling the Cincinnati office, that's the foreign division, you will then obtain your domestic estate. Okay. Your social security number is a domestic entity from its inception. It was issued to you by your parents applying for a social security number using the form SS5. What you're going to do is go online and do the electronic format of the SS4. You're going to take your SSN, which is already a decedent, because the name on that social security number is a juristic person. It is a subcorporation under the United States. So when you select that your estate is deceased, it's not you, it's the company. A company is dead until it has employees running it. That is their law. That is what they do. If this wasn't the case, and this only pertained to if I was dead, then the IRS system would not let me input my social security number with my name to obtain an estate for myself. If I am not declared dead, I am declaring myself as the executor of the estate. People do this all the time, especially when they've been diagnosed. Let's say they're terminally ill, and the doctor tells them that they have 7 years left. Well, now is a good time for them to start getting their estate matters and their affairs in order. So they could be their own executor to handle all of this information, to gather the EIN and get ready to pass on all of their assets to the next generation. Very same thing here. All right. Your name and social security number is an entity, just like an LLC. It is dead until someone operates it. Up until this point, if you haven't done this process, you didn't know that. Now you know. Ever wonder why employers, when they hire employees, they take out what's called a dead peasant life insurance policy on their workers? And the workers sometimes are unaware of this. And this is how some employers are able to offer certain insurance policies and pensions and different benefits to their employees is coming directly from that dead entity, and they don't even know about it. Okay. From there, after you've obtained your domestic estate, you are to convert it into a foreign estate, a disregarded separate entity. This is a process called entity reclassification, and it's a special form that you fill out. It's IRS Form 8832. You're going to transfer this domestic estate, convert it into a foreign estate. So now this takes care of the responsibility of you having to file 1040 forms. If you're an employee and you receive a W-2 at the end of the year, you will not have to file. However, you can file if you would like to claim expenses, because the trust will then own that estate, which will in turn own the SS4. It can claim its expenses throughout the year as a business expense through the Foreign Express Trust filing. Now, the Foreign Express Trust files a 1041. The social would file a 1040. Now, there's different schedules that goes along with it in order to get this done, but it is very possible you can do that. There are certain things that you can claim. Mostly everything that is considered a non-direct tax, like liquor and tobacco, that's a direct tax that's part of the U.S. Constitution. But everything else is very specific, depending on if it's employee related. It's depending on a certain percentage by how much you make. If you are a contractor and you're hiring independent contractors, well, all of those different details, such as Social Security taxes, Medicare taxes, FICA taxes, all of those things are different, and there's a certain percentage that would be owed. That's domestic, and that is not a part of the Constitution. So those expenses, including sales tax, all of those things can come back to the trust. A lot of corporations use this to their benefit. They would have a corporation and have that corporation regarded as a separate entity under the foreign trust. And that gives that corporation the opportunity to be tax exempt. So it's at zero from its inception. When a company is at zero from its inception, all of the monies that it spent, that is non-direct tax to the US per the Constitution, can then come back to them as an expense. And so once they receive that lump sum of money, they just utilize that lump sum of money for next year's expenses, which enriches them the next year. Because there's a next year where they didn't have to use their own money out of their own account that came from the profit. They're just recycling. And that's how you get rich. That's how companies do it. Now, just like your domestic estate is converted to a foreign estate, you can do the very same thing with your LLC, corporation, partnership, any entity that you have. If it has an EIN number, it can go under the Foreign Express Trust. Okay, so you can take advantage of that. Now, your Foreign Express Trust is one thing, but the trust enterprise is another. This is the entity that you would use to do your day-to-day banking and your administration for the DMV, for the insurance, for collecting all of the monies that your businesses make. For example, we know that child support is highly unconstitutional. Now, sometimes it does come into play if the father is not doing their job. But a lot of times, 90% of the times, a lot of the fathers out there are having issues with that, and it's completely unconstitutional. It really is. The thing about it, if they're being taxed and there's monies coming out of their paycheck directly from a child support order, it's because it's connected directly to their social security number. So a trust enterprise would completely help that type of situation, because if that type of person would open up a trust enterprise where the trustee that they hire or contract with uses their social to go and open up this trust enterprise bank account, they could take the routing and checking number, give that to their employer, and now the father can have his monies going directly to that trust enterprise account. Because his name and social security number is not attached to it, there's no longer any monies coming out of that individual's paycheck. Especially if he works as an independent contractor. He simply just provides a W-9 to his contractor saying, I no longer want to be paid in my name, but paid in the trust enterprise name. That stops that problem. Now he can collect his money, still be a father, and give the child what he needs, but at least is nowhere near as much as what they're taking, because we already know that 100% of the money that they take is not going to the child anyway. And during that time, it's in their best interest to go and shut down that child support case number and participation number, right? So a trust enterprise is really a U.S. fiduciary. It works on behalf of the Foreign Express Trust. Okay, it does all of its banking. It does all of its administration. We use this for registering automobiles in trust as well. Some states are very honorable, and they allow you to avoid the annual registration fees. The whole point is that trusts do not pay taxes. I'm not talking about domestic trusts. I'm talking about foreign express trusts specifically. That is the only one that most attorneys do not offer their clientele Because they don't know about it. They weren't taught about it. It's spendthrift trust, community trust, living trust is so standard. And all of these are domestic artificial trust that's controlled by statutes and codes. If it's controlled by statutes and codes, that means it passes the US court test and US control test, which in turn means it will be taxed. You can use these trusts to avoid taxation throughout the year, but at the end, when the settler passes, you're going to be taxed, the beneficiaries. That's what's going to happen. If you win the lottery, that money needs to be paid directly to the trust enterprise, not your name. If it's in your name, you will be taxed, right? So trust enterprise is going to handle all bank accounts, 401ks, 403bs, Roth IRAs, pensions, 1031 exchanges for real estate transactions, escrows, pensions, lottery if you win it. All of those things need to go into the trust enterprise account with a trustee that has a social security number, which is clean. They can open the account for you. Your money is going to there completely separate from you. You don't own it. The trust does. And on top of that, the Foreign Express Trust owns the trust enterprise EIN number as well. Here's an example of what that looks like. Here's a business that I had opened a while ago, and I did the entity reclassification process. I placed it under the jurisdiction of my Foreign Express Trust, right? What comes back is this specific employer ID number for that business. They've placed it under the Foreign Express Trust. They say, we've approved your Form 8832 entity classification election. We have approved your election as a foreign eligible entity. Now remember, it once started as a domestic entity. Now it's elected as a foreign eligible entity under that Foreign Express Trust, which was established in another country, with a single owner. So the trust is the single beneficial owner for equity purposes. Now this company, it is to be disregarded as a separate entity. That means they are no longer looking for this business to file 1040s or 1120s or whatever form, depending on the type of entity this business is. It's not looking for it to file by itself. It needs the assistance of the foreign trust, which it is under. So that means my foreign trust will now file taxes for the business if I choose to do so. If I choose, hey, we've spent $70,000 this year in business expenses. Let's file our forms to get some of that or almost all of that money back. The business itself wouldn't do it. It would need the Foreign Express Trust to do it. These are how companies outside of the United States are enriching themselves. This is why they don't question the inflation. They don't question the high taxes that they paid throughout the year, because they know it's going to come back. The more they pay up front, the more they get back, and they can use the money that they get back in the form of a refund to just handle next year's expenses, further enriching them. This is the process. We're not talking secured party creditor. None of that works. None of that teaches you to go to court and win. None of that teaches you how to file taxes. None of it teaches you how to read the actual law. And now we're understanding that the SPC process was a ploy to distract. So we want to get away from that. Now I wanted to go into this code here in California. This is the probate code. It's under trust law section, division 9, part 6, rights of third persons. It's going over how to fill out a certificate of trust. A certificate of trust is what is going to be needed to open your trust enterprise bank account. Okay, so it says here, the trustee may present a certification of trust to any person in lieu. See if I can bring that over there. in lieu of providing a copy of the trust instrument to establish the existence or terms of the trust. Okay, it only establishes the existence or terms of the trust. It does not mean you provide every single detail of the trust to whoever is requesting to look at it. Our certificate of trust is really just 2 pages. However, our declaration of trust may be 2 or 3 or 4 or 5 pages, maybe 7, depending on what you have. But we don't need all of that when it comes to opening a bank account. It says a certification of trust may be executed by the trustee voluntarily or at the request of the person with whom the trustee is dealing. So B, the certification of trust may confirm the following facts or contain the following information: the existence of the trust and date of execution of the trust. So if I had a company that was established May 5th of 2017, Cinco de Mayo 2017, and we are in the year 2022, and I'm just starting my declaration of trust. Did you know there's really 2 definitions of trust? One is implied and one is expressed. If I were to say my trust is implied, that means that me and everyone else who's involved in the trust have been verbally talking about it. We verbally came together and made this trust. However, later on, we decided to write it down and express it. So the verbal part is the implication, implied trust, and the expressed part is the putting it on paper and registering it down in the county. So if my business began Cinco de Mayo 2017, I can say that the implied trust began a few months or even a year before Cinco de Mayo 2017. It was implied. A trust is really a verbal agreement. It's a meeting of the minds. That's why 2 or more is required to come together. It doesn't require paper. It doesn't require signatures to establish it. That's just if you want to prove it to somebody. But you can operate in trust without the paper, a meeting of the minds. It's just a handshake, at least 2 or more, right? So, number 1, the existence of the trust and the date of execution of the trust instrument. So my certificate of trust would say, for this example, February 2017, and the business started May 2017. So now, guess what? That business is covered under the trust. Number 2, the identity of the settler or settlers and the currently acting trustee or trustees of the trust. So you have to have the name of the settler listed on the document and the names of the trustees. It also has to give the powers of the trustees, what they can and can't do. We just simply say they have the power to open accounts. They have the power to hire other fiduciary agents. They also have the power to do administration on behalf of another entity, which is that foreign express trust. They have the power to take and hold property. So you can get very unique and detailed with that. Number 4, the revocability or irrevocability of the trust. Is it irrevocable or revocable? We always go with irrevocable. Now, that does not mean that it's forever. That just means that once you place property in trust, it stays there for as long as possible for the duration of the terms of the trust. I don't care if you have a revocable trust or irrevocable, you cannot go longer than 25 years. That is the key number. It needs to be stated in the trust that it's 25 years. Once you reach the 24th year, that is where you extend it if the settler is still alive. If the settler has passed within that 25 years, hopefully you have added a successor trustee to come in and take over. But if that settlor has passed within the 25 years and there's no one else, it's just stagnant. That means that that trust becomes an immortal trust, and it will last forever. This is why trust is so powerful, and this is why the right type of trust, they don't teach you to learn how to operate, because it will last forever. In fact, if you take property into a trust and there's nobody to care for it, let's say the settlor's passed, let's say the foreign trustee has passed, right? Or whoever is the trustee has passed, the assets will stay in the trust. And let's say there's no one to come and, purchase it from anyone because the other person can't accept the valuable consideration, and there's no one to take care of the property. Well, it is now up to the county to take care of it for free, and it will stay in trust for as long as possible. It will. It's very, very powerful. So what we're going to do now, you can continue reading this. It's going to tell you the additional information that you need to open up a bank account and what else needs to be listed in the certificate of trust. But I'd like to go into the enterprise aspect. I'm going to read this for you guys. What is an enterprise? It says the enterprise means the related activities performed either through unified operation or common control by any person or persons for a common business purpose, and includes all such activities, whether performed in one or more establishments or by one or more corporate or other organizational units, including departments of an establishment operated through leasing arrangements, but shall not include the related activities performed for such enterprise by an independent contractor, provided that within the meaning of this subsection, a retail or service establishment, right, which is under independent ownership shall not be deemed to be so operated or controlled as to be other than a separate or distinct enterprise by reason of any arrangement which includes but is not necessarily limited to an agreement that it will sell or sell only certain goods specified by a particular manufacturer, distributor, or advertiser, or that it will join with other such establishments in the same industry for the purpose of collective purchasing, or that it will have the exclusive right to sell the goods or use the brand name for a manufacturer, distributor, or advertiser within a specified area, or by reason of the fact that it occupies premises leased to it by a person who also leases premises to other retail or service establishments. Now, they have said a lot here, but to take away, the enterprise is operating on behalf of another organization. Okay, this is what you're going to use, because your foreign express trust with its foreign EIN number, it cannot open any bank accounts. Ask me how I know. The money will freeze and stay there, and there's a whole process in trying to get that money out of there. You don't want to experience that. So you're going to have to do what McDonald's does, what Walmart does, Target, all of your high chains, your high retail, they have enterprises opening bank accounts for them because they do not want to pay taxes. Now, your foreign enterprise, we utilize, there's a certain way to apply for it. And in the course, you see that within the sophomore class, we utilize the laws of TEFRA, right? The great Jonah Bey has taught about that. The laws of TEFRA, Tax Equity Fiscal Responsibility Act. Once you have an EIN number with a 6 or 7 million series number after the dash of your EIN sequence, this means you're under the tax exemption section of the Internal Revenue Manual. That means that the bank is not going to report anything that you do, even if it's over $10,000 to the IRS. They're not going to report it. However, they will do that for all other EINs that do not have a 6 or a 7 after the dash. This is how you avoid audits. You need to utilize tax-exempt organizations as your enterprise that are qualified to do your everyday banking here within the United States. Okay, so what type of irrevocable trust enterprise are we utilizing? And that is called a GRAT, a Grantor Retained Income Trust. What is that? I'm sorry, here it is, a Grantor Retained Annuity Trust. The acronym is a GRAT. This is what I have opened. This is what all of our students have opened. It says, in a grantor retained annuity trust, the grantor creates an irrevocable trust and retains the right to receive for a specified term an annuity based on specified sums or fixed percentages of the value of the assets transferred to the trust. A grantor retained annuity trust is specifically authorized by the IRC Section 2702 A2B and 2702B. For federal tax purposes, this trust is treated as a grantor trust. This is exactly what I tell you guys to open when you conduct your Internal Revenue telephone interview call with an agent. I tell you to get your specific phone number over the phone, and certain questions that they ask you, how we fill out that SS4 form, it will give you a grantor trust and operate it as a foreign entity. Same thing here with the trust enterprise. You're going into the bank account and they will ask you what kind of trust this is. You'll say irrevocable, and then they'll tell you, well, what type? Most people didn't know that they were going to ask that question, but they're looking for any one of these. Now, why are we selecting this one? Well, most of us commonly, when dealing with opening a trust, the banks are looking for you to put funds and assets into it. This one covers monies from your businesses. It covers lotteries. It covers inheritance, and it covers life insurance policies. That falls into inheritance as well. It covers the ability to enter into what's called securities. Securities is what people in this space have been looking forward to for a very, very long time. What I mean by securities is the opportunity for your businesses that are under express trust to sell or offer for sale contracts, units, bonds, mortgages. For example, let's say you opened up a life insurance policy. We've all heard of the term COLI, corporate-owned life insurance, or BOLI, bank-owned life insurance. This is what the banks do. They find them a highly qualified CEO. They take out a life insurance policy on him, anywhere from $5 to $7 million. If he passes, the bank gets $5 to $7 million minus whatever they've agreed to give to his family. But during the life of this CEO, he will create bonds, contracts, units. When I say units, I mean trust certificate units. And because the bank or corporation has a permit or a license with their local banking authorities, they can sell that agreement utilizing the collateral of the life insurance policy. This is called collateral assignment. They can sell that piece of paper, that note, to the local banking authority for the face value of that note. This is how you utilize life insurance during the life of the settler. If you have a trust who's the beneficiary of the life insurance policy, then guess what? The trust will receive the money from that local banking authority. Now, you have to get a permit to do it. For example, if we were to go into the state Florida, let me go into Florida right here. This is a title is Business Organizations Common Law Declarations of Trust. It's section 609. If I go down to 609.05, if I had a trust established in Florida, how would I qualify to do something like this? It says qualification with the Office of Financial Regulation. Before any person may offer for sale, barter, or sell any unit, share, contract, note, bond, mortgage, oil, or mineral lease, or other security of an association doing business under what is known as a declaration of trust in this state, such person shall procure from the Office of Financial Regulation of the Financial Services Commission, that's a mouthful, they will procure a what? A permit or a license to offer for sale and sell such securities, which permit shall be applied for and granted under the same conditions as like permits are applied for and granted to corporations. So even if you have a declaration of trust, you still have to apply for it. Now, why the permit? If you didn't really have the permit, you would have to file with the SEC, the Securities Exchange Commission, to be able to offer for sale these type of paper, this contract, share, units, notes, and all of that. The cool thing about utilizing your trust under a declaration of trust, if I were to have an unincorporated association or my trust enterprise, which is doing business as the name of my express trust, and I applied with this institution here in Florida, right here, it's the Division of Securities. I applied here for this license. I will then be able to make bonds, make contracts, make any kind of note I want off of the contract of the life insurance policy, sell it to this division, and what comes back? The face value of the security that I offered. This is funding the trust. This is what we're doing. This is how we're going to do exactly what the SPC process, secure party creditors, were trying to do with attacking the so-called money that's located in the Social Security account and all of that nonsense. That doesn't pertain, that's a fairy tale. Do not do that. You will catch a charge. So many people have done an erroneous process and have suffered for it. Okay, all the rumors out there that you hear that people have accessed this magical account where the Social Security number is with the Federal Reserve banks and all of that, with the numbers on the back of the social, all of that stuff is not for you to use. You have to do it the investor way. Learn commerce, and that's what we're here to talk about. That's what we're trying to do. We are doing it. So this is information that is only available to our members within Patreon, but you have to complete your process of setting up the Express Trust and everything that's a part of the course so that you may graduate out of the senior course into another level of learning. Okay, this is serious learning here. So with that being said, that's going to be it for this video. Hope you enjoyed it. Trust enterprise, very important to do your banking and to keep you anonymous from the public eye. This is what the states do. This is what the banks do. This is what your government does. Monkey see, monkey do. That is what we do. I like that pun. Until next time, thank you. I'll see you next time.